Good day everyone, and welcome back again. For those of you who are watching this video, I want to wish you a happy holidays, because of course this is Labor Day weekend. And as always, you know that my name is Anthony Reeves. I am a Social Security disability attorney, and welcome to another edition of Q&A Social Security Disability Today. Got a couple of questions here, so let's go ahead and get this thing shaking and baking. Someone asked me, because they got a letter in the mail that said their disability is going to be under review, and they wanted to know, what does that mean, under review? Okay, when you apply for Social Security disability benefits, you've gone through the process, and then boom, you've gotten approved. You're probably doing the happy dance, you're good with the world, but one of the first things that I tell people all the time after they've been approved is, be aware, you're not going to get Social Security forever. The process was not ultimately designed for you to get disability benefits for the remainder of your life or into retirement age. The idea is that the disability benefits were designed to provide you some modicum of compensation during the time period when you are unable to work, with the idea that hopefully your condition will improve to the point where you're able to return back into the workforce. Now let's be real here. There are going to be some conditions that just aren't going to improve with time, and Social Security recognizes that. However, they do take it upon themselves to do what they call a continuing disability review. That means usually about every 3 to 5 years, there's no set time period in there, but every 3 to 5 years, Social Security will pull your case back up to determine whether or not they think you are still disabled. Well, how do they do that? Well, pretty straightforward. First, they look at the benchmark as being when were you determined to be disabled? And then they look at today. So let's say you were found disabled back in 2006. Your review is now. So they're going to look at your condition in 2006, and they're going to look at your condition now to see if they are the same, if they're worse, and if they're better. How do they do that? Well, what they're going to do is they're going to do almost the same thing like they did for you before. Now, what they're going to do is they're going to start asking your friends, your contacts. They're going to start reaching out to your doctors. And so they're going to be looking at the period of time from the time you became disabled, which was 06 for this example, all the way to 2011. Now, I know some people say, well, I was real bad, and you want to go back to the time period before 2006 because that's what really caused you to have your problems. No one is disputing you were disabled in 2006. No one's disputing you were disabled in 2007, 2008, 2009, 2010. They're saying in 2011, we want to see if your disability has stopped or should it still continue. Now, usually one of two things happens. They get all your medical records, they review your file, and then they make a determination that either one, you are disabled, and they just keep on going, or two, you're not disabled, at which point in time the appeals process kicks in. Now, first and foremost, keep this in the back of your mind. If they find that you're disabled now, and let's say for some weird reason, you're still relatively young, you're in your 40s or your 50s, does that mean you're not going to get another review? Absolutely not. They keep doing them on a regular basis. So what ultimately will happen is about another 3 to 5 years, guess what? You're going to have another review. Now, with the next review, they're not going to go back to 2006. They're going to go back to 2011. So let's say this was 2016. They're going to go back to the last time they determined you were disabled, which was 2011, and that will be their benchmark. Now, here's where it gets a little weird. If they make a determination that you are no longer disabled, what recourses do you have available to you? Well, you can do one of two things. One, you can say okay and ride off into the sunset, or two, you can appeal it. Now, typically within your letters of appeal, they'll tell you, if you want to appeal, you have a right to ask for your benefits to continue. Here's what you need to understand. If Social Security makes a determination at some particular point in time, usually if you get denied by a judge, not a disability hearing officer, but a judge, that you are no longer disabled as of the date that was determined, you may have to reimburse Social Security for all that money that you received during the time they were doing a review of your case. So how does that actually work? Well, let's say for instance, they tell you, you're no longer disabled as of September 1, 2011. So you decide, I'm going to appeal that sucker, and I want to still keep my benefits going. So during that process, they do a review, it's probably a reconsideration appeal, and what they're going to do is they're going to have what they call a disability hearing. That means you're going to go, depending on how your state works, but usually what will happen is you'll go to some disability determination office, one of the medical providers that Social Security works with office. You'll probably sit in a room, you'll talk to one of the state workers who will ask you a series of questions. They'll give you the opportunity to review your file to make sure that they have everything in there that they're supposed to have. They'll give you a chance to basically make your argument about your condition, and then they'll make a determination. If they determine that you are no longer disabled, you then can appeal to go before an administrative law judge. At that time, you can still ask for your benefits to still continue. Then you go through the process and you will actually go and boom, you'll get to a judge, and either you'll be approved or you'll be denied. Now please, people, keep in the back of your mind one thing. The new Social Security ruling that just came down about a couple of weeks ago basically says that if the judge makes a determination that you are no longer disabled, this goes with a new application as well as a continuing one, I'm pretty sure with a continuing one, and you, let's say for instance that you get denied by the judge and you want to file a new application based on the same allegations, you can't do it. So it's kind of, now I will tell you, with regards to a continuing, it's going to be weird, because with a continuing, if the judge says up to this point you can no longer say you're not disabled, then this is what's going to happen. You have a choice. Under the new rules, you can only do one of two things. I know this may sound confusing, but follow me along. You can either appeal that judge's decision, or you can file you a new application, but you cannot do both. You can file a new application, because under the new rules, you can't have both. You can't file an appeal of the review and then file a new application if you're still alleging the same type of thing. This is one of those things where I tell people, make sure you talk to a Social Security representative, not an attorney rep or an attorney rep, because that is something that you need to be fully aware of. Also, you need to be aware of this. If you are denied by a judge and you've been receiving benefits during the time when they've been reviewing your decision, you may have to reimburse the federal government. So keep that thought in the back of your mind. Okay? All right. Second question. Someone asked me, why does Social Security get so fired up over unemployment benefits? Okay. First and foremost, I want people to recognize there's nothing in the regulation that prohibits individuals from applying for unemployment benefits. And the fact that you receive them does not necessarily mean that you are not disabled. So Social Security is not going to basically cank your case because you've received unemployment benefits. Now, there's technical aspects, so if you got an SSI, the earnings portion is kind of weird, so we won't talk about it. We're talking solely from a disability standpoint. But the thing is that Social Security has a responsibility to make a credibility determination. And when they use that, they're going to look at your situation and think about it like this. When you apply for Social Security, you're telling the federal government that due to your medical condition, you are unable to work. When you apply for unemployment, you are telling your state government that you are able to work if work was available. Now, it's weird because what you're going to find is that, and I'm going to tell you this right now, because people always ask me this, well, how did judge view this? And I always say it depends on the judge. Because let's be real, people. You know, your bills ain't going to stop getting paid just because you apply for disability. You know, that man ain't going to come out there and keep the lights on and say, hey, can you wait 2 years until my disability check? And I got you, boo, on the backside. It's not how it's going down. What's going to end up happening is if you don't have money to pay those bills, guess what? Stuff gets turned off. And so people make difficult choices. But Social Security is going to look at, especially a judge, at your situation in its entirety in determining should the fact that you received unemployment or that you applied for unemployment be held against you with regards to a credibility determination. So, if you find yourself in a situation where you've applied for unemployment and you're receiving unemployment for a period of time and you're wondering if that's going to negatively affect your case, it's a case-by-case basis, people, because it depends on the judge. It depends on the circumstances by which you applied for unemployment. And if you say, what do you mean by that? Well, think of it like this. Let's say that you got hurt, you applied for unemployment, you still kept looking for jobs, and you got a job, and then you stopped and you got unemployment again, and then all of a sudden you were like, you know what, I can't do it, and so you went and you applied for Social Security. That's a circumstance that happens a lot. A judge may be sympathetic towards it. However, some judges may not be sympathetic. They may say, well, are you still receiving unemployment? Did you tell them that you're not able to work anymore? Well, no. Well, then why not? So it's important to understand that Will unemployment be taken into consideration? Yes. The receipt of the benefits themselves is not necessarily going to be a death for your case, but it will be taken into consideration in terms of credibility because of the fact that most people who apply for unemployment are asserting to the government that they can work, but when you apply for Social Security, you're saying you can't. This is why it's important to make sure you have a good representative to kind of help you understand how this may impact your case, and especially one who's had the opportunity to go before judges, so they can give you a good feel of how that judge is going to respond either way. So just kind of keep that in the back of your mind. Again, everybody, I want you all to have a safe holiday. Make sure that you take care of yourselves. And as always, my name is Attorney Anthony Reeves, and this is another edition of Q&A Social Security Disability Today.